Good afternoon, everybody. It's Maurice Bertha speaking, welcoming you at the POPI training today. We have presented it a week ago, but due to a lot of people requesting us to redo it, we decided to do it today. However, we were scheduled to do the new regulations with you, but there's no regulations published up to date. So we couldn't continue with that, and we will still reschedule as soon as the new regulations are made available. The PowerPoints will send to all the member schools in English Afrikaans after we have presented this matter. And the presentation will take place with myself and Anke, part of our team of the Westhuizen attorneys, and she will do the legal side and I will do the practical implication of certain determinations in the Act that we wish to highlight for you. Please use the chat function if you want to ask questions, and we will answer questions as we continue if possible. Otherwise, we will thereafter, after the session, email the answers to the specific people that asked the questions. And we want to say to you, don't hit panic stations now, because the POPI Act is already in place. It can be enforced. However, for the schools, there's structures and certain aspects that's got to be put in place, and we have time up to the 30th of June. And we are available to assist the schools, and we've already supplied all the schools, member schools, with a POPI policy, and we will assist you in creating your structures and appointment of the statutory appointments that you need to fulfill the POPI requirement. So to continue with this, I'm going to allow Anke to do the introduction of the Act to you, and whereafter she will hand over to me, where I will then continue again with the practical implication of the specific determinations of the Act. We hope you enjoy the session. Looking forward to meeting you at the school when we are more available. Thank you.
Okay, good afternoon, everyone. I'm Anke de Wet. I work with Maurice Bertha Consultants. I'm an attorney, and I've looked at the POPI Act for you guys so that you don't have to go and look and try and figure out yourselves what is going on. So what does POPI stand for? POPI stands for the Protection of Personal Information Act. So if we talk about POPI, that is what we're talking about. And just before we head off into POPI in detail, there's another act that you might sometimes confuse with POPI, and that is POIA. Okay, so POIA stands for Promotion of Access to Information Act. So you'll see the difference: protection of personal information, promotion of access to information. So the reason I'm also talking about POIA is you'll see later on in the slides, one of the responsibilities of the principal as an information officer of the school is to also make sure that there's a POIA manual. And POPI protects the right to privacy and therefore personal information, whereas POIA gives us a route to follow when we want to access certain information. Okay, so that is the only reason why I'm explaining this to you. If you see POIA later in the slides, you can come back to this slide and just refresh your memory on what the difference between the two are. As Maurice explained, I'll give you what the Act says, and he will then go into detail with regards to practical implications of whatever I discuss with you that is in the Act. So a lot of you might ask, we already have so much admin, why do we need more? Why do we need to know about POPI? Why is POPI important? So POPI is important because it aims to limit direct marketing and unauthorized databases. All those phone calls that you get, all those emails, SMSs, people irritating you with marketing. POPI aims to limit that, and POPI actually puts rules in place so that your personal information cannot be traded and shared beyond what it was originally processed for. Secondly, your personal information cannot be held without good reason. So someone cannot just have your personal information without having a good and a valid, legitimate reason for actually holding on to your information. And then thirdly, to align our practices with what the rest of the world is already doing. So POPI comes from international legislation, it's based on that, and it therefore promotes trade between the different countries, because if they know we're also adhering to those international best practices, then they know that they can more easily trade with us without being afraid that some information will be lost or shared beyond what we are actually allowed to do. And then lastly, it promotes data security. So you all will remember media telling us about some of the banks who had data breaches. So POPI actually places a responsibility on anyone keeping personal information to keep that data secure, so that it does not land in the wrong hands. With identity fraud these days, or cyber fraud with payments being made, data security is becoming all the more important every single day. So Maurice will quickly give you some practical implications for schools with regards to what I just said.
Yes, everybody. In a nutshell, I'm going to highlight two issues for you relating to schools. The first one is sending out advertisements from the school. You will have to look at your admission form for the schools, where the parents must have the option to indicate, are they going to send, do they wish to receive any marketing material? Because some schools do have fundraising by sending advertisements to their parents, and you will have to indicate to the parents that they have a choice. Do they want to receive it? And if they want to receive it, they can nominate SMS via email, whatever other electronic or hard copies is not that great of an issue. But if you want to use social media where there's personal information, emails or cell phone numbers has to be known, then you need the person's that they can give consent that you can send it to them. Other factor raising questions these days at several schools is your COVID-19 register where the person signs in. The ideal situation would be to let everybody complete a separate page, and the page can then be filed thereafter. But most of the schools have registers, and if you write into register your name, your surname, your address, your ID number, your cell phone number, you've got to give all of that information. Then that information is available on a page where 30 other people might log into the school. So bear in mind then, if I come and I'm number 16, I've got all other 15 people before me. All their private and confidential information is actually available to me. So we'll have to have a very strict security there by limiting that somebody cannot take a photo or write something down or try to remember some details that's available there. And later on, we will discuss this register again, because I'm collecting this information. And it serves a purpose because I've got to be able to track people if there's a positive COVID case. But the question is, how long are you going to keep that details? And how are you going to get rid of it? What are you going to do after 2 weeks? Throw it in a dustbin? It's still available to the whole world. But you have to bear in mind that you have to have a plan. How are you going to deal with this? And how long are you going to keep it practically? And that will come out of the session a little bit later. In a lighter sense, I want to say to you that a school is like a gold mine of information. If you start digging there and you've got 1,000 learners, you've got most probably 2,000 parents' information. Outside institutions wish to get that information to start marketing and maybe start harassing people. But the fact of the matter is we cannot allow them to get to that information. And that's what the discussion today is about. I'm handing back to Anke.
Thank you, Maurice. So where does POPI come from? It comes from the Constitution. In terms of Section 14 of our Constitution, all of us have the right to privacy, every single one of us. And this right to privacy actually includes us the protection from the unlawful collection, retention, dissemination, and use of personal information. So we have the right to privacy, and therefore we also have the right for the protection of our personal information not being shared beyond what we wish it to be shared for. So what POPI brings is a proactive approach instead of a reactive approach. So now, because of POPI, there are rules in place that people have to follow if they are holding on to personal information. And they already have to comply with those rules proactively. So in the past, we would have been reactive. We would have found out something happened. We would have had to go and try and prove that. But now we have POPI. If they don't adhere to those rules, automatically they don't adhere to POPI and therefore also not to our right to privacy contained in the Constitution. So Maurice, what are the practical implications of this?
Right, Anke. Yeah, the practical situation regarding this is, all of us, like we said, get irritated with marketing phone calls, and then we ask ourselves, where does it come from? The school can never supply cell phone numbers and contact details of parents to any other person without the consent that they have. Otherwise, the school is going to become the guilty party in supplying information that, look, I collect the information for a specific purpose, and now I'm not using it for that purpose if I supply it to other people just for supplying, and they can most probably create a business situation out of that. And then the other practical question is, if I send an email, and yesterday at a school we had a simple example, I am requesting donations from companies, so I send an email to 10 companies. But the emails of all 10 companies are available to the other people reading this email. And the question pops up now, do the person that I'm requesting to assist us, to sponsor us, do that person really want the other people to know that he's involved in my school, number one? Number two, that he is supplying donations? Because if that goes around, then this guy's going to be flooded with requests to other schools. So you've got to keep your sponsors' information very confidential to yourself. Nobody can get access to that. And that's where we should look at an email policy, maybe saying that, put a little guy on your shoulder saying to you, if I send this email out and there's 20 email addresses, should I not blind CC the other people so that I only direct it to one person, but they cannot see the other people who are emailing this request to? So my advice to schools are, we have to utilize the BCC option much more to enhance this whole process of protecting personal information to that. Back to.
Okay, thank you, Marius. So what is the purpose of POPI? So POPI aims to protect. It protects by protecting our constitutional right to privacy. And it gives rules, so that says it regulates. So it regulates any person or entity who has personal information. And lastly, it provides us with remedies to protect our personal information. So protection of our constitutional right to privacy and regulation, because there are actual standards and rules that everyone must adhere to. And it also provides us with rights and remedies when we feel that our personal information has been shared beyond what we initially gave consent to. So Marius, what can you think can be the practical implications of this?
Firstly, the practical implication is that every school does have to have a POPI policy, indicating how are they going to adhere to the requirements of the POPI Act. And that's essential to guide everybody, to help them, assist them making decisions, and to guide them whenever they have to answer to any person regarding certain issues regarding personal information. So in that view, the POPI schools policy is not a negotiable. It has to be there for that. Then we have to, the POPI policy that's got to be, was applied to your schools will have to be adjusted to your specific needs. We will get to that later, but who's going to be in charge of the personal information? If somebody wants to apply for information, where does he going to start? And the Act is actually very clear, and it's not the best news, but the principle, you are responsible and in charge of all of this, and there are other people to be appointed to this. But going back to my example earlier of the COVID register, remember, protect, comply, and regulate. So we have to look at when we collect information, if it's on an admission form or in a register, an attendance register, whatever it might be, I have to make sure that I handle those the information supplied to me in those three essential issues that Anke has just mentioned. Back to Anke.
Okay. Now I just want to go into a few of the definitions that we can find in the Act, so that when you hear something that you can understand where it's coming from, or when you read the draft POPI policy, that you can just use these definitions to understand it better. So the first very important definition is processing. How do we know that we are processing personal information? So you'll see here collection, receipt, recording, organization, collation, storage, updating, modification, retrieval. It goes on and on and on. And I tell all the schools, I think the golden rule here would be to say, if I wonder if I'm busy processing personal information, I probably am. Okay. So don't go and try and be technical on when you're processing or when you're not processing. If a parent fills in an enrollment form, you're typing it over into Excel, you are processing that personal information. So because it's such a broad definition, I think just have the rule for yourself. If you're wondering if you're processing personal information as the Act says, you probably are. Okay. So Maurice will give you guys some practical implications for this.
Yes, I want to concentrate on the practical things that we see at the school, for instance, is the admissions form. In the admissions form, if you should request the religion of a person, is that a necessity? Is it really needed? Do you really want to have that? What do you want to do with that? And those are the questions over here. Should you indicate, for instance, race? What has that got to do with the whole story? So which personal information are you going to collect? And we've got to make a decision on that. Is it really necessary? Because the moment you create information that's useless information, meaning that you're not going to use it specifically for the purpose that you're collecting it, and it's just additional information, it's like a nice to have, you're creating a risk for yourself. So firstly, see what information do you need and only concentrate on what is really necessary. And then we do have a lot of information. I said the school is like a gold mine of information. In the financial office, we've got bank account numbers, we've got different invoices, we've got different agreements, and all of that documents are at the school in a safe house and everything. And the question comes up, how long are you going to keep this information of all of these external parties? Because it's sensitive information. They supplied it to you for a specific purpose. And when the deal is gone and everybody's paid everybody and the contract has ended, what are you going to do with it? Obviously, for record purposes, for receiver or for audit inspections, you have to keep it for a specific while. So don't just throw it away. And we did supply a list to schools, member schools specifically, regarding giving indication of all documents, how long will it be required. The grey area at this stage is, again, the register entering at the gate. How long are you going to keep that information? Practically, if you look at the COVID, it should only be 14 days. But how are you going to get rid of it? That's the question. You cannot just throw it in the dustbin. If you burn it, there's risk of that. So a shredder most probably will be the best option. And the school has got to make a decision on that and write that into their policies. I'm back.
Okay, some further definitions. A responsible party is also defined in the Act. And a responsible party in your scenario will be the school. A responsible party is any body or person who is keeping personal information or processing personal information. So the school will qualify as a responsible party. And then another definition is a data subject, and that's simply all of us are data subjects. You are data subject, the parents are data subjects, the learners are data subjects. So if there's talk about data subjects, then it refers to the person or the entity who is giving his or her personal information to the school. And then information officer, I mentioned it earlier. An information officer will then be the principal of the school. So each responsible party has to have an information officer, and we'll deal in more detail with the information officer's responsibilities a bit later in the slides. Then another definition, and this is probably the most important one, what qualifies as personal information? So quickly have a look here, guys. There are 3 slides just for this definition. Race, color, age, disability, religion, education, medical, financial, symbols, email addresses, telephone numbers, biometric information, personal opinions or views. So almost the same as with processing. Once again, I want to give you guys a golden rule. If you're thinking or wondering if you're working with personal information, you probably are. Because once again, the definition of personal information in the Act is so wide that, or broad, that it basically includes almost everything. So once again, don't try and be technical. If you're working with information of a person, you can go and check in the Act, but I think as a rule for yourself, just say to yourself that you are actually working with personal information because it's such a broad definition. So what can the practical implications of this be in a school environment? Back to Marius.
Thank you, Anke. Yeah, it's well known with educators that all educators has access to all the information on the learner's profile, because at the beginning of the year, you divide all the learner profiles, the blue or white files, into registered class, and the registered teacher has to check that all the children's profiles are there. But if you open that profile, you get a lot of sensitive, possible sensitive information, and information that cannot be shared with anybody. And that now becomes obligation of the registered teacher to look at the information in that file, but to utilize it only to perform your work that you're able to do. You cannot go to a staff room and say, hell, I've read through my profiles of my children. Do you know I've seen something interesting about that child? And the parents, do you know the parents are divorced, or the child has been adopted, or there are the following cases against this? Because remember, that file carries the history from preschool right through to grade 12. So be very sensitive for that file, and you cannot let those files lie around. We had a school where we visited where this file obviously was lying in the staff room, and it was open for everybody to, and that's not correct. You cannot do that. The other problem is the financial officer or bursar's office. There's even more sensitive information. You can think if people apply for exemption to pay school fees, they've got to supply very, very lots of personal information before they can qualify or be evaluated for exemption. And that brings that's a lot of information concentrated there. And not everybody should have access. Certain people should have access, keywords, keys, to enter into that office. In that office, you cannot let things lie around. Yesterday, we had a question at a school, but I'm marking papers in my classroom and I'm going out. You cannot leave marked papers with marks to everybody, or class lists with marks on it, so it's visible for everybody on your school table, your desk in front of the class. You cannot do that. The next challenge is parents that are getting divorced. Sometimes they wish to get the school, and the legal representatives wishes to get the school in the middle. So educators approach and say, give me your personal opinion. Is the child happy? How's the child doing? Does the child look if it needs care for you? You cannot get involved. That's personal information that you cannot share. That is where the school should keep it out of that. And let's deal that the attorneys deal to each other. Let them get a court order. And should you supply that information, it must not be an opinion. It must be factual. And indeed, what is factual? Only the marks are factual. So don't start spreading a perception that can be used in a court case, because you can get up there. The other problem is gossiping. A lot of people has the tendency, but I have now this secret information. I have to deal it with somebody so that somebody can know about that. Be careful. You cannot do that. And we should refrain totally from gossip and only share information. If you've got information about a learner that's sensitive, in the school structure, you've got an SBST. If they deal with the parents of that, they are basically statutory empowered to do that. And should that be even going further to the department support team, base support team, or you report it to people like a social worker who has the right to go there. If you're concerned about a child's well-being, it's Section 110 of the Children Acts guide you very clearly on that. Then the last one, employees signing in on a register at school where they use biometrics, putting their fingers down. How do we keep that safe? Because your biometric, your fingerprints are quite valuable information. And the people who wants to conduct some crime issues, if they can get hold of that, they can cause serious damage to you. So this is the practical implications that we have to bear in mind at a school. And I'm giving to
Okay, then I think it's the last of the definitions that we're going to quickly look at, and that is the definition special personal information. So some of the personal information or things qualifying as personal information, as I mentioned earlier, actually qualifies as special personal information. And this automatically gives us the idea that the Act feels even stronger about protecting this personal information more than any other personal information. And examples of this is like your race, your sex life, biometric information, Maurice just mentioned that, your political persuasion, union membership. You guys can just imagine with all these strikes, and there are maybe a few union members who don't want to take part. Some of them have literally been murdered. Criminal behavior. So actually with special personal information, there are stricter rules when you want to process that information. So think of it, if you have these special personal information fields on any one of your forms, go and consider if you really need them there. Because there are specific rules, and most importantly, that person needs to consent to such special personal information being processed. And Maurice will actually now also talk to you just about what the practical implication for special personal information can be.
Right, thank you, Anka. I want to quickly address two questions. We have a question saying, but what can I share parents' personal information with other parents? No, you can't do it without consent of that parent. And that's why giving the consent of that, we will have to get WhatsApp groups where people that wants to establish, for instance, a WhatsApp group to function in a school, that all the people participating in that WhatsApp group should sign some rules. And part of the rules will be that they agree that the people in the WhatsApp group can have access to their telephone numbers. Secondly, they will have to sign that saying that they will not distribute the other people's numbers on that WhatsApp group and make it available to parties not knowing what is there. So the situation regarding this is that the fact is you cannot supply somebody else's. Then I had a question regarding if I have registered class lists with marks on it. Yes, those marks, you have to have it in your presence, right, or locked up. Not other people should be able to go in and say, okay, this is the name of the child, and that's it. That's why the matric results are not coming like in the old times against names. It's coming against exam numbers. And that's why universities are also refraining from putting names and marks on the boards. They are actually only giving the numbers to that. Right. And then the question, are we allowed to share data, information or personal information with the police? Unless there's a court order, no, you cannot do that. Secondly, the police has got to get a court order that orders you to do so, to supply it to them. You can also not have a policeman interacting with the learner without the parents' knowledge and the parents being present. Let's come back to the other practical implication is what about the enrollment form? On our admission enrollment forms, we do ask a lot of information and we must make sure that we do what is needed, because the parent signing that form has the right to approach the school now and say, why do you need this information? What are you going to do with it? What is the purpose? And how does it affect my admission of my learner to the school? And that will be measured against the legal requirements. What can a school request from a parent? So we've got to look at that admissions form, and then on that admissions form, maybe create a sentence where the parent has to agree, number one, that should the child's photos be utilized for the yearbook or on social media or on advertiser marketing, the parent must be able to agree to that. Otherwise, you cannot use that information, and that creates an admin burden where we discussed yesterday, and I think that it would be logical for the register class teacher to do the administration whose photos cannot be placed or not be used in any form, and discuss that then with the person running your Facebook or social media portfolio. We discussed the fingerprints because that is something that you've got to keep it safe and not lie around. How to deal with requirements for appointment of educators. This is now a total new dimension. You cannot become an educator without giving a police clearance. You cannot work on school grounds without a police clearance. So your criminal record will be exposed if you have one. And this is a legal requirement from the school. If you want to work at the school, you have to give consent. You have to supply this information. Otherwise, you cannot work in the school. So you'll have to make a decision if you want to work somewhere or you want to apply for a financial institution for a bond. They're going to ask you questions. Have you ever been declared insolvent? Have you got any criminal charges? What is your monthly income expenses? So depending on the legal requirement of the other side, you'll have to make a decision, and then if you want to participate or work or apply for that, you have to give your personal information. So you're actually giving consent that this person can deal with it. However, that person can only deal with it for the purpose that you're giving it to them. They may not use it in any other way. They cannot collect it with false intentions. Right, back to Anka.
Okay. When can personal information be processed? So now we're just talking about how careful you need to be and how strict the rules are, but there are instances where you are allowed to process personal information, and let's have a look at that. When it's necessary to carry out actions for the conclusion or performance of a contract. So that would be you are sharing your service provider's detail with one of your vice principals or another employee or staff member, because they will be the person administering that service agreement between the school and the service provider. So it's necessary to process the information to him or her. Secondly, if processing complies with an obligation imposed by law, that example Marius mentioned now about there's an obligation on that person to provide that certificate to be able to be employed on the school grounds, that's a good example of that. If processing protects the legitimate interest of the data subject, so you can think of a situation, for instance, where you are suspecting that something's really wrong at one of your learners' houses, and you need to refer the matter to a social worker in terms of the Children's Act, then there's a legitimate interest for that child for you to process his or her information to the social worker. And it's actually by law that you have to do it. Then number 4, if processing is necessary to for the proper performance of a public law duty by a public body, not going to go into that. And then number 5, if processing is necessary for pursuing legitimate interests of the responsible party. So now this is the other way around. Number 3, we were talking about the parent or the learner, not about the responsible party, which is the school. But what if the school has a legitimate interest to pursue? A good example of that is the parent does not pay school fees, and the school has to process the parent's information to an attorney to do collection of that school fees. Okay, so those are instances where you are allowed. That is a guideline you can use to know when you are allowed to process personal information. Okay, Marius has a good example about this also.
All right, thank you, Anke. Before going to the practical implication, I just want to answer a question that popped up quickly. So can the police come and do raids on the school grounds for illegal substances, weapons, or whatever? Yes, if there is a reasonable belief that there is a criminal act on the school grounds and children are contravening and making themselves guilty of this, yes, the police can come and search. If they find, however, then there's normal procedures for how it should then be handled. So the parents will then be contacted, and then it's a case between either the schoolers institute action against the learner or the police, but not the police and the school. We've got a recent court case ruling in the West Rand where you tried the school and the police did both. You cannot do that. You can either the school act within the school rules if something is found wrong then, or the police must lay criminal charges and take the matter further, depending on what do they get, from 9mm pistols to drugs or whatever it might be on the school ground. But the police can come and search, and that is part of the South African Schools Act and also the regulations regarding safety and security on the school grounds. What about a competition launched for school fundraising? If you want to raffle out and you've got a weekend at a specific lodge or somewhere and you want to, the children are selling tickets and everybody, and you are collecting the funds, then the question that comes up, the winner. Now the winner is Mr. X. Does Mr. X want us to make it public that he won this or not? Because we cannot make him public as the winner and his name be thrown around and said, here is our winner and all of that without his consent. So when we do fundraising competitions, we will have to inform the people who we are requesting to participate and donate and give money and buy tickets. We'll have to inform them that, are you aware that the winner name must be made available? And I say must, why? Because if you launch a competition and at the end of the day, we say we have a winner, but we're not making that available, you will become not trustworthy regarding this competition. So it would be better for any fundraising that right from the beginning, that people participating must accept that if they are the winner, that their name would be made public. And taking a photo, publishing that, that's also a consent that you will have to get from the person participating in this competition. Right, back to Anke.
Okay, thank you, Marius. So practically, you guys can just include that in your rules. So you know that small little form that you complete to partake in the competition, and there's always those few small lines telling you how it works. Then just add that rule there and say that the person is giving consent for his or her name or photo, etc., to be published on the school's Facebook page or something like that. So what are the conditions for lawful processing? So if you want a further guideline to know if you are processing information correctly or if you are allowed to process information, you can look at these conditions that we find in the Act. So number one is lawfulness, lawfully and in a reasonable manner. So lawfully, you will look at the slides that we discussed previously to know if you're doing it lawfully. Minimality, so not excessive. Do not ask questions on your forms that you do not really need the answers for. If you go and look at your fields on your forms and you're asking questions that you don't really need the answer, or you've been asking them for 10 or 15 years, but you've never needed them, remove them. And then consent. So we've assisted a few schools already, but I would advise that on your enrollment forms, you add a POPI clause saying why the personal information is being processed, and also asking the parents to give consent for that processing to take place. Then secondly, purpose specification. So collection for a specific purpose. If you look at the fields and you do not know what the purpose is for collecting that information, then you're not supposed to be collecting it. If you don't have a purpose for the information, remove that field. And also not keep the documents for longer than that purpose. If the purpose has been served and you've kept the documents for the time frame that we've indicated in that other document Marius referred to that we sent to our member schools, then that must be destroyed. You cannot keep it if the purpose has been served. Okay. Next, further processing. Further processing actually refers to processing information so that the child is enrolling, and then we further processing it to another person or another party. So an example of this can be if someone comes to your school and say, we'll sponsor the school with 10,000 Rand, but in turn, you will please have to give us your database of parents and learners with their contact details. That will be further processing. And you're not allowed to do that except if the parents then give their consent. Okay, so be careful about that. Information quality. So you need to ensure that the information you have on children in your school and parents are kept accurately, that it is complete, that it's not misleading, and that it's regularly updated. So also include a little sentence on your enrollment form that says that it's the parent's responsibility to update the personal information that the school has as soon as it changes. Parents' cell numbers and email addresses change on a regular basis, and inform the parents on this form that it's their responsibility to update the school as soon as that personal information changes. Then openness. So keep documents of processing done by the school. So if the school gives information through to any other party or information is shared amongst different departments in the school, document why it's being done in a policy or in another document, or if some parent gives consent for you to share the information to another party, keep in writing the proof that that parent has consented. Okay. And notify data subjects that their personal information is being collected. That forms part of that paragraph I mentioned earlier that you need to include on your enrollment form. And then I see I have 2 6s here, but it's 6 and 7, security safeguards. So that refers to where are we keeping our personal information? Is it secure? Who has access to it? Is it protected from loss or damage? And most importantly, from unauthorized access. Who has the passwords to the system that has all the personal information to it? Who has the key to the safe where sensitive personal information is being kept? So that is what security safeguards is about. And then data subject participation. So a parent can come to the school and ask the school, what personal information are you keeping? I want to know of myself. So the parent can come and ask you, and then you will have to show them what you have, and they can ask you to update it if it's incorrect, and they can also ask you to delete it if you don't have a legitimate reason for actually having that personal information anymore. So Morris just has a quick discussion for you on this.
Right. I think if you've listened to everything that we said today, there's a lot of questions that can be raised. How do I do this? What should I do? What can I do? What can I not do? And that's why the POPI policy is essential there. It will assist you in making your decisions. It will also assist you in giving answers and know what to do, and also reach your goals regarding personal information collection. So the POPI policy is specifically right, that it's got to guide everybody on the school grounds. We do have 2 questions, and the one is, would we supply the wording that is needed specifically at the admission form for the POPI to fulfill in that, and what should you ask there for the photos and using the all of that, and also on the competition. Yes, we will supply that to our member schools. What about the personal information of educators is a further question. Every educator is a juristic person in the Constitution of South Africa, and you've got all the constitutional rights that everybody else has. So nobody can demand from you to make your personal details available. And I think this question is more directed at, should I give my cell number to parents? Should I give my email address to parents? No, there's no force on that to do that. If they want to contact you, you contact it like any person working at a banking institution. You cannot phone them afterwards and discuss bank issues with them. You have to contact the branch or the bank where they're working and make an appointment. And that rule is here. So you don't need to supply that. Obviously, if you are going to become part of the WhatsApp group, yeah, they're going to have access to that, right? And the children and the information of educators personal on a computer available. That's why you've got to get firewalls and certain PIN numbers and security installations on a computer system, so that only people that need to know has to go into it on a specific level. The principal will be able to go totally right through to all the information. He will have access, but you can limit it according to the need that other people have, what they need to know, that you can limit the information that they would have access on. Right, I'm back to.
Okay, so educators and even other staff members on the school grounds work with children on a daily basis. And the Act then also mentions children specifically. How are they protected by POPI? So POPI says that a competent person must consent on behalf of a child who is also a data subject. It must happen. So a parent or a guardian must consent on behalf of a child for that child's personal information being processed. But now the question is, who is a competent person? So the Act's definition doesn't really make it very clear. It says any person who is legally competent to consent to any act or decision being taken in respect of any matter concerning a child. But the school environment is a bit complicated in this regard, and I want to go back to Maurice so that he can have a chat to you guys about why this can be a difficult scenario.
Thank you, Anke. Yeah, this is a grey area in the Act, and I think we will, as time run out or certain people asking questions regarding the POPI Act, we will be guided more about this. Because if you look at, running to the SGB elections now, and who is a parent in the SGB election? It will be the biological parents, guardians, right? Order where people have to supervise and have children take them in for safe care. And then lastly, it is also if a person takes the responsibility to pay all school fees for a learner, that person is recognized as basically equal to a parent. But the fact is now he can vote in the SGB, but now there's certain specific issues regarding the child has to be referred to an LSN school, and they've got to conduct interviews and personal information has to be collected. Is that person then paying the school fees still the competent person? I don't believe so. And this is the grey area, who's the competent person, because we also get where we do have houses where parents passed away due to HIV, and you've got two minor children living with a 16 or 17-year-old who's running the household there. So is that person the competent person? As it is, yes, that person can take decisions on behalf of that children currently. So if defining the competent person, I think the guideline that I would suggest for schools to do is, if there's children not staying with their biological parents or guardians or people appointed to oversee them, then you must ask the biological parents to give consent that other people can deal with the information of the children. And then they must specify, it can be the grandmother, parent, uncle, whoever it might be, but we need a paper trail giving us consent that we know that we can talk to these specific people. And I think that's the golden rule we will have to do to not get ourselves into the hot water here. And I'm again back to the divorce cases where the school ends up in the middle. Be very, very careful to who do you give information, because you can end up in court. Back to Anke.
Okay, now we getting to the responsibilities of the information officer and his or her deputies. So I mentioned earlier the information officer will automatically be the principal of the school, and the principal will, in his capacity as information officer, then be allowed to appoint deputy information officers to assist him or her with all these tasks that I'm going to discuss with you now. And the schools will probably have to do it because the principal's plate is already quite full. And he or she won't be able to do all of this by themselves. Okay. So firstly, in the Act, we have a few, and then in the regulations, we have further responsibilities and duties. So in the Act, must encourage compliance with the conditions of lawful processing. So how does he encourage compliance? He encourages compliance by making sure that everyone adheres to POPI policy of the school. Dealing with requests made to the school. If a parent comes to the school and asks the school, what personal information are you keeping? The principal or the deputy information officer appointed will assist with such requests. If the information regulator comes to the school with an investigation, someone went and complained about their personal information being wrongfully processed, then the information officer of the school will deal with that investigation and assist the regulator. And then otherwise ensuring compliance. So if someone makes a misstep in terms of the POPI policy, then that person will need to be warned, and that will be done by the information officer or deputy information officer of the school. So in the regulations, we have further responsibilities or duties, and one of it is a compliance framework must be developed, implemented, monitored, and maintained. So your compliance framework will be your POPI policy. It must be developed. We've already developed our POPI policy and we've sent it to you. It's a very thick document. Please go and make it your own, read through it. Contact us if you have any questions, and then implement it if you've made it your own. Monitor the compliance in terms thereof and maintain it. If you realize that something's not working or you need further measures, then you must change the POPI policy to suit your needs. Okay, and then a personal information impact assessment has to be done. I'll discuss that in more detail with you and tell you what needs to be included in that assessment in a further slide. And then this is where PIA comes in, Promotion of Access to Information Act, that first slide where I explained the difference between the two. POPI also says that the information officer needs to ensure that there's also a manual for PIA at the school. Okay, and then the last two, make sure that internal measures are developed and there's adequate system to process requests. So that will also form part of your POPI policy most probably. And then make sure that internal awareness sessions are being held at the school. So this is actually what part of that. If you are at a school and your principal asks you to attend an awareness session, then he's actually just adhering to his or her responsibilities in terms of the regulations contained or from the Act. Okay, practical implication. Who will be the information officer of the school? I said already, it's the principal of the school. Cannot sidestep it, unfortunately, but the principal can appoint deputy information officers. Make sure that you understand what your responsibilities as a principal are with regards to being the information officer at school, and ask us. It's a statutory appointment. Ask us if you need any assistance. We're all going to figure POPI out as we move along. Almost nothing has been implemented yet, and therefore we're all going to learn as we go along. Okay. What should be in place at your school? So you have until middle of this year, end of June, to get your POPI policy and all your internal measures in place. The principal must be appointed and deputy information officers must be appointed at the school. And then you must do your risk assessment. So I'll explain that later, it's still coming up. You must put the necessary policies and procedure in place, and you must make amendments to your documents where necessary. So go and look at your enrollment forms and any other form that you send out to parents, and make sure that you're not collecting personal information that you're not allowed to, and that parents know why you're collecting personal information and that they're consenting to you doing that. And then also provide training to all persons dealing with personal information. That is part of what we're doing right now. Okay, here we finally getting to the risk assessment. So what personal information is the school collecting? Okay, the school must only collect essential personal information. I've already mentioned it a few times. Go and look, what are you collecting? Are data subjects like parents giving you permission to do that? Go back to your enrollment form and make sure that sentence is included there. We have already drafted an example. If you want it, please just email Adele and we will make sure that it gets back to you. I mentioned earlier, security. Where is personal information being kept? Who has access to it? Who has the password for the computer? How are the user privileges set up with all your systems keeping your personal information? Are there perhaps a few people who are having access to much more personal information that they really need to properly perform their duties? Okay. And then lastly, are you destroying personal information when it's no longer necessary? So that forms part of your risk assessment. So I would advise, before you guys go and finalize your POPI policy, go and do your risk assessment and then finalize your POPI policy with reference to what you have found out, and put measures in place at your school with reference to what we've given you now. What can happen if I don't adhere to POPI? So complaints can be filed at the information regulator. I mentioned the information regulator earlier. They will be sending an investigation team to your school, and if the investigation finds that something is in fact wrong or went wrong, then they will refer it to the enforcement committee, and the enforcement committee will then issue you with a notice. And if you don't comply with that notice, it will be an offense. And the offense can actually lead to a fine or imprisonment not exceeding 10 years. So we haven't heard of anyone being found guilty of such an offense yet. We will keep you guys updated. If we feel there's some risks for you guys, we will communicate it to you. Okay, and then I also want to just quickly note that there is specific protection with regards to account numbers of data subjects. So that goes back to your financial officer or your bursar. Account numbers are special. Okay, so please protect them more than anything else. Okay. And there's also administrative fines. And then the other part is that other than actually filing a complaint with the information regulator, parents or service providers or learners can go and make a claim against you for damages as well. And that is what I would be careful about. So if you have a parent who has quite a lot of money and can go to an attorney and you didn't follow POPI, they can make a claim against you. They have to prove it, obviously, for damages. So rather not find out how this feels like. Be careful when you're working with personal information. And that is what we have for today. I see that there are 2 more slides. And I will quickly, not slides, questions, and I will quickly go through them with you. So the one question is, should learner profiles be kept in the safe, or is it fine to keep it in the general office in cabinets? Should the cabinets be locked and only the registered teacher has access? Sure, you guys, it all depends on how easy it is to access your general office. If it's easy for anyone to come and walk into your general office and open a cabinet, it's not really safe enough. So if it's really difficult to get in there and no one is allowed except the people actually working there, then it should be okay as long as that office is then locked when no one is there. But if there's an influx and outflux of people all through the day, I would suggest that the cabinets be locked. And yes, you need to restrict access to those learner profiles and ensure that people are not trying to access learner profiles that they don't have any reason to be accessing. If it's the registered teacher or another teacher who teaches for that learner, then it makes sense. So it depends on every school's scenario. Okay. Then, are teachers allowed to have learners' cell numbers? If it's the registered teacher, yes, it should probably be okay. But my question here is, why do you need a learner cell number? Okay, I know with online learning now, teachers having to share certain work. As far as I know, most teachers actually share the work with the parents and not specifically the learner. I would advise that communication be kept between the parent and the teacher to avoid certain situations happening between educators and children or learners. We unfortunately have had to deal with educators getting into relationships with learners of a sexual nature even. So I think ask yourself why would an educator need a learner's number in the first place? And if there's not a good reason, then communication should be preferably be kept between the parent and the educator. So assess the situation. If you're unsure, go up in the channels in your school to your departmental head or your direct supervisor and the principal. You're not alone in this. If they don't know the answer, then they can always ask us to assist. But please don't make mistakes because you didn't ask. Okay. We have another question for a school group. Can you have a central policy which is used by all schools? I'm not sure what school group you are referring to, but if the school makes use of, for instance, WhatsApp groups, then there needs to be a policy in place that regulates WhatsApp groups, and that would preferably be your social media policy. The school's social media policy and the social media policy of the school actually links with the POPI policy of the school, okay, quite closely. I just want to double check here on my side if there are any other questions. I don't see any. Let me just make sure. Okay, I see someone said I'm talking about the POPI policy. You know, they were, even with FICA, they said that they might have one policy drafted and implemented like for all law firms or for all schools, but we haven't seen them yet. Okay. So we haven't seen a centrally drafted POPI policy that all schools can use. So that's why Bruce, our specialist in policies, drafted you that draft policy. And if there is a central one that comes out, then you guys can look at that. But for now, not yet. I see Latoya also now mentioned it might be a group, like a group of independent schools. If you're an independent school group, then yes, you can have one POPI policy and implement it across all your schools. But remember, there will be differences, like I now said, with the general office. Maybe the general office is not accessible at one school, but at another school it is. So I think you should be careful, get your policy and implement it across all your schools in your independent school group, but be sensitive for the fact that every school functions on its own and might have different requirements that are necessary to look at in your POPI policy. Is it okay to communicate with learners who have left the school already? Well, I'm guessing that you're talking about learners who you might have a very good relationship. You built it up and they're now studying and you're keeping up with them and they're studying. probably those learners would hopefully then be major learners, not minor learners anymore. And then it shouldn't be an issue, because the moment they're not children anymore, I don't see an issue with you discussing something with them. If they're over the age of 18, it should be fine. I'm just worried about educators talking to minors, educators talking to learners in the school, and something happens. You just say the wrong thing and it explodes, and a parent sees the messages and you get into a lot of trouble. Okay. Any other questions? I don't see any other questions popping up for now. So yeah, we finished a bit earlier than we thought we would. Morris had to leave for an urgent meeting at a school. I hope you guys learned something from this. We had some good questions, a little bit more than in the previous session. As I said, we're all learning from this together. We haven't really seen POPI being implemented, and we haven't really seen how the information regulator works. We haven't seen how the complaints work, but we will find out, and we will grow with you in this process. If it's necessary for us to amend our draft POPI policy, we will do it and send it out. But as a golden rule, be very careful when you're processing personal information, and please contact us where you are unsure. That is why we are here. Okay. Thank you guys so much for joining us today. I hope you have a good afternoon, and we look forward to seeing you again or talking to you again when we have our further sessions of next week. Okay. Have a good afternoon. Bye-bye.